Hi, this is Rick Durfee, the senior attorney of Durfee Law Group, and we're here again today to answer some frequently asked questions about estate planning. And in particular, in this session, we're going to talk about what is commonly called a durable general power of attorney. Sometimes people call these a financial power of attorney, and there can be some variations of this, but the durable general power of attorney does one very specific function. Number one, it names people that you would want to make financial and legal decisions on your behalf in the event that you are for any reason unavailable. So it could be that you're traveling out of the country, it could mean that you're busy doing other things, or it could mean that you've had a medical event and you're incapacitated. A durable general power of attorney authorizes the people that you've selected to make those legal and financial decisions for you. The durable part has an interesting history. That means that this power of attorney to act on your behalf continues even if you are incapacitated. Historically, the power which arises under the doctrine of agency, the agent can only do what the principal can do, and if the principal is incapacitated, the principal can't do it, so neither can the agent. What does that mean? For the most part, something you don't need to worry about. The durable part means even if you're incapacitated, the people you have named in the document to act on your behalf can do so. Now, to protect themselves, some people will use what's called a springing power of attorney, which says that they cannot do this unless you are incapacitated. It's been our experience that the springing power of attorney has some problems. The problems we've encountered is that financial institutions, banks, brokerage houses, and sometimes title companies will say, yeah, how do we know that that person is incapacitated? Prove it. And when we say, well, what will you accept as proof? Their answer is something like a court order or doctor's letters from multiple doctors. So it becomes burdensome and onerous to prove that the individual is in fact incapacitated. So an alternative to that is to make that power of attorney presently effective. But it's a bearer document, which means that the person who has it in their hand, if they're named in the document and they possess the original or a certified copy of the original, they can exercise the powers. Now, the danger of that, I sometimes compare that durable general power of attorney that's presently active to a loaded gun. You only hand it to someone you trust, you don't leave it laying around the house, and you put a trigger lock on it. So it's our practice in our firm, most of the time, clients willing, we hold on to that original here in our office, and we're the trigger lock. We will not release it unless one of a few conditions. Number one, the client says, it's my document, please give it to me. It's your document. If you want it, you can have it. So if the client says, give it to me, we will give it to you. The second one is, your doctors tell us that you're incapacitated. And we want that written verification so that we can protect you and make sure that the document's only used appropriately. The third one is we have credible evidence that you're missing for at least 30 days and we can't find you. In decades of experience working with this, I've had that happen a few times. It's been people that have gone to foreign countries and they disappear. We don't know where they are. We can't find them. Or the other one that's happened a couple of times is small aircraft accidents where we know the plane didn't land, we don't know where it is, but we can't find the people. So in the meantime, somebody's got to pay the bills and keep the lights on and keep the house from getting foreclosed. So we employ the durable general power of attorney in that situation. The fourth condition is we as a law firm verify that in fact you are incapacitated and that it is in your best interest to use the document. So here's an example. Daughter calls the law firm and says, hey, I'm looking in mom's notebook here and I see that there's a power of attorney, but this is the copy. I can't use it. Can I get the original? We say, well, why do you need the original? And the daughter says, oh, because my mother or my father is incapacitated. In which event we say, thank you, we'll get back to you. We call the client. Now, sometimes we verify and turns out, yep, we check with the healthcare provider, we check with the hospital or the institution, we do some due diligence, and sure enough, that individual is incapacitated. And after we investigate and do our due diligence, again, we determine, yep, that's actually going on, and yes, there are reasons that it needs to be released. In which case, we have pre-signed authorization from the client to release the document. But there have been a number of instances where we call the client and the client answers the phone and we have a pleasant conversation and it's perfectly obvious that they're not incapacitated. In which event we say, so what's going on with your son or daughter or family member, whoever it is, that's asking for your power of attorney? Now, a couple of responses we get. Once in a while we get the response, oh yeah, I'm going out of the country for a period of time and I want my family member to be able to pay my bills while I'm out of the country. Or, yes, I'm advancing in years. I want to add my family member to my bank accounts so that as needed, they can help me pay my bills. Great. Or the third one that we get sometimes is, holy mackerel. Yeah, this individual in my family has gone off the rails. They're having significant legal or financial or substance abuse issues, and they're trying to get my money. They're trying to rip me off. Protect me, help protect me, please. And when we possess that document here in our office, we can decline to release it to that individual, and we can help the family take appropriate measures to protect themselves and their finances. So the Durable General Power of Attorney, a very important and powerful document that allows other people to make financial decisions on our behalf. As we advance in age, the probability of us becoming incapacitated before we actually die is 100%. It happens to everyone. And the probability of us needing help in keeping our finances in order and paying our bills is also pretty much 100%. It happens to all of us. So the reason we have these durable general powers of attorney is so that we can select in advance who we want to do that. In the absence of such a durable general power of attorney, often the only recourse family members have is to go to court and to get a court order to declare that mom or dad is incapacitated, that they're incompetent, and that they cannot handle their affairs, and that so-and-so needs to be appointed to do that for them. That process, which depending on the state is either called a conservatorship or a guardianship, is expensive, it's intrusive, and now the court becomes your partner and the overseer to appropriately make sure that there's no abuse or mismanagement of the funds. So we are able to take care of the finances, but now the process to do that is vastly more expensive because we have to account to the court, we have to get permission from the court, we have to show the court that everything we're doing is justified and reasonable and appropriate, and if it's not, we get spanked. The same duty, fiduciary duty, to use funds for the benefit of the principal, of the person who set up the power of attorney, attends the durable general power of attorney, but it is handled outside of court without that additional expense and layer of oversight. There are circumstances where the durable general power of attorney, even if you have one, should not be used. It's still appropriate to go to court, and that is particularly true if there's any instance of abuse or exploitation of people that are vulnerable and not able to watch out for their own interests. But otherwise, most of the time, the family members who are loving and caring and who are going to do their duty and who are going to treat mom and dad and their finances with respect are the ones that are best suited to step in and help pay the bills. So that durable general power of attorney, one of the basic legal and medical emergency documents that everyone should have. Bottom line, if you're over the age of 18, if you're an adult and you have stuff, and you're not immortal, you're not a superhero with superpowers to somehow defy death, you need one of these. People ask all the time, we had somebody call today in our office and say, do I really need this? Yes, you really need this. You should really do this. And that's something, if you have questions about it, concerns about it, if it's old, should I update it? Yeah, you should talk to a qualified legal advisor who can counsel you with regards to that. We encourage you to go onto our website to look at some of our other articles and videos and to call us or email us with questions or concerns. Thank you.